Welcome to the Deep Dive, your shortcut to being well-informed. Today we're untacking something truly foundational, really. It's like an invisible blueprint governing so much, often without us even noticing. I'm talking about the Transfer of Property Act of 1882 in India. Think of it as the bedrock, the essential operating system for basically every property transaction, big or small, across the country. So our mission for this deep dive is to explore this key legal framework. We want to pull out the most important insights and show why it's still incredibly relevant today. Whether you're, say, a first-time homebuyer, maybe a seasoned investor, or even just curious about how property changes hands, this stuff matters.
It really does. It's fascinating because this act, it's truly a cornerstone of Indian property law.
Yeah.
And what makes it quite unique and what we'll focus on is its specific attention to transfers that happen between living persons. Inter vivos. It's all about those deliberate, chosen interactions people have with property.
Yeah. Exactly. And just to assure you, this isn't going to be some dry legal lecture. We're aiming to uncover some, frankly, surprising protections and essential principles, cut through the jargon, make sense of something really crucial. Okay, let's dig in. All right, let's start with the basics.
Yeah.
The fundamental purpose of this act. It's mainly about governing property transfers between living persons. That's the inter vivos part we mentioned. Now, it covers both movable and immovable property, but let's be honest, the really intricate stuff, the most impactful bits, they mostly revolve around immovable property, land, buildings, that sort of thing.
And its scope is pretty broad. Historically, it applied across India, though there was that notable exception for Jammu and Kashmir before Article 370 was abrogated. Oh. And crucially, it only applies to transfers made by the act of parties, meaning when people actively, intentionally decide to transfer property. It's like a deliberate agreement, a conscious choice. It does not apply to transfers that happen by operation of law. So things like inheritance when someone passes away or property acquired through a court order, those are handled by completely different sets of laws.
Okay, that's a really important distinction. So given that, how does the Act actually define transfer of property? What's the core legal meaning here?
Well, Section 5 gives us the precise definition, and it's quite specific. It calls it an act by which a living person conveys property to one or more living persons, or to himself and one or more other living persons. So what this really boils down to is the act focuses on transactions where there's a deliberate act, giving up rights, acquiring new ones, from one living entity to another. That specific wording highlights the intentionality. It separates it from, say, just receiving property under a will after someone's gone.
Right, okay. And bringing that definition to life, This act covers the ways property usually changes hands. There are transactions we generally know. Things like sale, obviously property for price, mortgage, using property as security for a loan, lease renting out property, exchange swapping properties, and of course, gift transferring property without any price or consideration, as the law calls it. So we've listed the types of transfers, but how does the act make sure these exchanges are, fair, transparent, legally solid? That's where we get into the fundamental rules of the road. These are laid out in sections 6 to 53A. These sections dictate pretty much everything from what can be legally transferred, who can transfer property, the right ways to do it, and even the different conditions and restrictions that might apply to a transfer.
Yeah, and one of the most fundamental rules here, especially for immovable property, land, and buildings, is that most transfers must be done using a registered instrument. A formal, registered document. This isn't just red tape. It gives legal certainty, transparency, creates a public record of who owns what.
Makes sense.
Another key element is consideration, which is basically the value exchanged, the price, the goods, the service, whatever makes it a real transaction, not just a casual handover. This value is generally needed for a transfer to be valid. Gifts are the big exception, of course. There, property is given out of affection or charity, no price expected.
And the Act does lay down some clear restrictions too, doesn't it?
Oh, absolutely.
Like property can't be transferred for an unlawful purpose. Seems obvious, but legally vital. And generally, you can't transfer future property, something that doesn't exist yet or you don't fully own.
Although, like most laws, there are nuances, exceptions.
Yeah.
Like contingent interests, right, for future planning.
Exactly. Contingent interests allow for some planning around future possibilities. But beyond these general rules, the Act also gives us specific tools, especially for when things get complicated or disputes pop up. These are what we call the important doctrines. Think of them as specialized legal safeguards. They ensure justice and help prevent unfair dealings. Okay, let's dive into one of those. The first aha moment, maybe. The doctrine of election. Section 35. This basically says if someone faces a choice between two conflicting rights and they can't legally hold both, they must choose one. Give up the other completely. Now, why is this an insight? It's not just about making a choice. It's a legal tool that actually forces ethical behavior in complex property deals. It makes sure no one unfairly gets the benefit of two conflicting claims at the same time, like the law saying, nope, can't have your cake and eat it too when property's involved.
That's precisely it. This doctrine is a great example of protecting fairness. Imagine a scenario. A property owner tries to transfer property they don't fully own, but in the same document, they also give a big benefit to the actual owner of that bit of property. The true owner then has a choice. Either accept the benefit, and by doing so, effectively agree to the transfer of their property, or reject the benefit and keep their property. They can't take the benefit and try to reclaim the property. It stops people from playing both sides of a tricky deal.
Or you can't double dip, essentially.
Exactly.
Okay, next up, the doctrine of lease pendens. Section 52. This sounds technical, but the core idea is critical. If a property is involved in a lawsuit, any transfer of that property during the lawsuit isn't valid against the other party in the case. So for you, the listener, what does this actually mean? If you were thinking about buying a property that's, say, stuck in a legal battle, how does this protect anyone?
Well, what's fascinating here is how lease pendens, which just means pending litigation, is crucial for the integrity of the legal system itself. I mean, if someone could just sell off disputed property while a lawsuit is going on, court judgments would become meaningless, wouldn't they?
Yeah, completely pointless.
This doctrine effectively freezes the property's legal status during the dispute. It makes sure that whatever the court eventually decides can actually be enforced. It's a legal shield for the court process.
Now, another interesting one, and maybe a bit counterintuitive at first glance, is the doctrine of part performance, Section 53A. This doctrine offers a unique kind of protection. It shields someone who's already taken possession of a property under an unregistered transfer as long as certain conditions are met. Which kind of sounds like it contradicts the registration rule we just talked about.
It does seem that way initially, and that's why it's so significant. It's a perfect example of the law sometimes putting fairness equity above pure formality. Imagine you've paid for a property, you've moved in, done your part of the deal, but maybe the final registration paperwork got delayed or wasn't completed. Technically, on paper, you might not be the full legal owner yet. But the insight here is this doctrine stops the original owner from just kicking you out simply because the document wasn't registered. It recognizes that your actions paying, taking possession, create a real obligation, even if all the legal I's weren't dotted. It provides a vital safety net for people acting in good faith.
That's a really important protection. Okay, then there's the doctrine of notice. This is the idea that a buyer is expected to be aware of existing rights on the property. And it's not just about what you're explicitly told, but also what you should have known if you'd made reasonable checks. It really underlines buyer beware, but with legal force.
Exactly right. The doctrine of notice pushes buyers to do their homework, their due diligence. You generally can't just claim ignorance if there are obvious signs, like existing tenants, or clear pathways used by others, or other visible claims on the property. This protects people who already have rights tied to that property, ensuring they aren't just swept aside because a new buyer didn't bother to look carefully. It promotes transparency, accountability.
Makes sense. And finally, in this group of doctrines, we have the doctrine of fraudulent transfer, Section 53. This one's pretty clear-cut. Transfers made specifically to cheat or delay creditors, they're considered voidable.
Yes, and this raises an important point about how the law tackles bad faith. Voidable means the transfer can be legally canceled or set aside by the person who was wronged, like a creditor who was deliberately defrauded. So this doctrine acts as a crucial check. It stops people from sneakily moving assets around just to avoid paying their debts. It ensures the property system isn't used to hide dishonest dealings.
So it's clear these doctrines add real teeth to the act. But why does this act, drafted way back in 1882, still matter so much today? It's definitely not some dusty old rule book sitting on a shelf. It's been amended quite a few times, hasn't it? Adapting to India's changing economy and legal needs.
Oh, absolutely. It's far from static. Its enduring relevance is, frankly, undeniable. It remains central to almost everything involving property. Real estate deals, planning how property passes down, succession planning, commercial transactions involving land or buildings. It's all underpinned by this act. It provides that fundamental legal structure, that consistent framework which makes these transactions possible and helps resolve disputes when they happen. It's like the quiet engine running a massive part of the Indian economy.
And that connects directly back to you, our listener. If you've ever bought a home, or maybe signed a lease for an apartment, or even just thought about how family property might be handled down the line, this act is there, working silently in the background. It's protecting your rights, defining the terms of ownership, ensuring clarity in these really significant life events. It's essentially the rule book for what's yours. So as we wrap up this deep dive, it's really clear just how vital the Transfer of Property Act of 1882 remains. Despite its age, it's a dynamic, essential piece of law. It truly underpins so much of how property is owned, exchanged, and managed in India today.
Indeed. The Act doesn't just lay out the mechanics of property transfer. Through those doctrines we discussed, election, part performance, lis pendens, it actively works, often quietly, to ensure fairness and prevent injustice. It provides that foundation of trust and predictability in property dealings, and that's absolutely essential for any society to function well.
So here's a final thought for you to maybe mull over. The next time you hear about a property sale or a lease or even inheritance, just consider how that seemingly simple act of transferring property is actually built on a complex web of legal protections and responsibilities. It's a whole system designed ultimately to make sure that what's yours